Hello, everyone, and welcome to tonight's program on estate planning. I'm Angela Dailey, WISE Executive Director. With our virtual format, we can now welcome participants from all over the country. So please, if you're not a WISE member, go to our website, www.wiseinvestors.org, sign up. The price is right. It is free. In 1997, a small group of women met in Orange County to put on an investment conference for women. To their absolute amazement and delight, over 500 signed up for this event, and they knew they were onto something. Fast forward, almost 25 years later, and WISE is still committed to its mission of financial education for females of all ages and all socioeconomic backgrounds. We do this because we believe that managing your money better will lead to more options in life, more opportunities, and the ability to fulfill your dreams. WISE works through community organizations such as Girl Scouts, Girls Inc., and universities. And despite an unprecedented year, we hit many records, including doubling our membership and having more events than ever. Tonight's program is part of our groundbreaking Tearing Down the Pink Wall series, where we gather the best and the brightest in finance to both inspire us and educate us. And that's what we have for you tonight. One of the best and the brightest estate planning attorneys in Orange County, Tamsen Reinheimer. Tamsen is, hi Tamsen, welcome.
Thank you, Angela.
Tamsen is a graduate of UC Santa Barbara and of, remind me, Tamsen, the law school.
Whittier Law School.
Yes, and she's a sought after speaker, an expert in all aspects of estate planning, trust administration, and probate. And she's also very committed to educating women on finance. We have a two-part program. First, we're going to talk to Tamsen about estate planning, get her best ideas here. And then we're going to get a little more personal with her and talk to her about her own career journey to becoming a prominent attorney. Evidently, drawing up a will is an anathema to most Americans, because despite the fact that no matter what our financial situation, we all need a will, and 68% of Americans do not have one. So think about this. If you die without a will, your estate and all your assets will be divided up according to the letter of the law and not your wishes. So that means that ex-husband that you never got around to divorcing, or an estranged relative, or worse, a relative you don't even know could end up with your assets. Now, layer on top of that the fact that, according to the Wall Street Journal, we are now in the midst of the biggest wealth transfer in this country's history. So we all got to focus on this. So we're going to get to it in a second, but just 2 items of housekeeping. Please put your questions in the Q&A box, not the chat box. And you may have noticed that we are missing one of our attorneys tonight, Kinnari Patel, who was called away for a trial. And I guess that's what happens with attorneys. So Tamsen, thank you so much. Welcome. Thanks for joining us and spending time with us tonight. So let's start at the very, very beginning here. Tell us, what are the components of a sound estate plan?
I am happy to do that, Angela. Thanks so much again for having me. And I do love doing these educational seminars because I really feel passionate about making sure that people have what they need in place to protect their wealth, but also to protect their family and make sure that their family doesn't have a mess on their hands when we all depart the premises, so to speak. And so what I'm going to tell you today is really based, of course, totally on my knowledge of California law. And I am aware that other states are different. California, as probably not surprising, makes things pretty difficult all around. We pay the price for our sunny weather and our oceans and mountains. So if you have questions that are state specific, I'll defer on those. But generally speaking, the most important component of all estate plans is the basic last will and testament. And I think it's a really common term that everyone's familiar with because, lucky for me, we have these TV shows now that are focusing on inheritance and succession, and it's bringing to the forefront my area of practice. But it's the old way of doing things. It can be a handwritten document. And essentially what it does is it leaves your assets to whomever you want. That's the core of an estate plan. Who do you want to leave your dollar or your million dollars or your pet or whomever to? That's the will. Now, in California, again, and in some other states, because we make it so difficult to live and die, pay taxes and death, we like to use what's called a living trust. The living trust is a replacement for the last will and testament. And the essence of it is to make it a lot cheaper, more private, and easier for your family to distribute your wealth when you pass away. The other most important things, and I can't harp on this enough, and I know I do get on my soapbox, but the healthcare directive. In a world where we're all living longer, the longer we live, the more likely it is that we're going to need someone to help care for us. And that healthcare directive across all states, it's called different things. In California, it's called an advanced medical directive. In other states, it's called a living will or a healthcare proxy. That document names the person that you want to make healthcare decisions for you if you can't make them yourself. And even more importantly, states what would you want to have happen with your medical decisions if you can't make them yourselves.
So those are the two basic components that we all need to be aware of, Tamsen. Okay, so tell us, how do we get started? How do we find an attorney that we can trust? What is it going to cost us? And third part of this question is, can I just go on the internet, download from LegalZoom a document and just put it away? Is that considered a legal will? And should I do that?
Yeah, great questions. And again, because I'm such an advocate, I really firmly believe that something is usually always better than nothing. And so wherever you get those documents to start with, something is in fact better than nothing when it comes to your medical directive, and probably in regards to how you're going to leave your estate as well. I get a lot of referrals for clients from my other clients. And I find that when people start to have the discussion with their friends and family, oh, I need to do that. I need to do a will. I need to do a trust. And then you say, well, who do you use? Well, I use this person. It is a good way to get the dialogue going. And if you find an attorney that someone trusts as well, it's a good lead in. But again, the internet, here we are on the internet sharing our experiences, and that's where people go to find those leads. And that's okay too. You just have to make sure to sort of poke around, make some phone calls, see who you fit with if you are indeed going to choose a lawyer, and, costs, time frame, what their practices are, make sure it's a good fit. I really believe that this is a relationship for clients. It's not just a one-off, procedure where you're done. You have to come back and see me over time. So you better really like who you're working with and feel confident with them.
So what about the typical fee? Just give us a range, a ballpark here. What for a basic will? And then, of course, obviously, as things get more complicated, they're going to cost more.
Right.
What if it's a simple document?
Right. So here in Southern California, of course, we have maybe a big difference in fees than in other parts of the country. But let's say if you're going to see a law firm or a lawyer in Southern California for what I would call a complete estate plan, a living trust, a will, powers of attorney, a healthcare directive. There are many lawyers who will do that on a flat fee basis for you, some who charge by the hour for complexity. But it ranges for, a single person could be $1,000, $1,500, $2,000. To a married couple with a couple of kids, it can be $2,500, $3,000, up to $5,000 for some of the firms around Southern California who offer sort of higher end packages, if you will. But I think, I always tell clients when they're shopping around, so to speak, you do get what you pay for. Right. So just be aware that the prices range dramatically. You really have to dig into what you're going to be getting when you're shopping for price.
And what would be the mistake that people would make? Let's say it's a young married couple. What they be making a big mistake by using LegalZoom? Yeah,
it's a great question. And I would say that it's not a big mistake, Angela, but We do a lot of projects for clients where we essentially undo all the LegalZoom documents. And that's not to say that they're always wrong or bad, but imagine if you were to be, let's say, selling your own home and you wanted to sell it as an owner. But do you know all the rules, all the requirements for the forms? No, you're just filling forms out and hoping for the best. And that does tend to be the case with some of these LegalZoom documents, is you don't know what you have when you're pressing in the buttons and picking what they're offering. So it's a little, it can be not quite right. If you have a really simple plan and you're just a single person, it might be okay. And I think the last time I looked, Angela, LegalZoom was charging still $500 for a will or a trust. So really good price wise, but be cautious is my tip.
Yeah, and it sounds like if it's more complicated than a very, very simple thing, you should definitely see an attorney.
I think that's exactly right.
Yeah. So now you've been practicing for many years here, and I'm sure you've seen a range of wills and documents and complexity. What are mistakes that you have either undone or you have to talk people out of when they're doing up their wills?
It's a great question. And I would say, again, in California, we use the vehicle called a living trust a lot. And the living trust, it's very much like, for those who are out there, it's very much like a business. When you form a corporation or an LLC and you give it a name, the Tamsen Reinheimer LLC, it's the same for your living trust. It's like a little entity that you add all of your assets to. It has a name, the assets are titled in the name. And that is the biggest mistake here in California, is they don't put their assets into the trust. It's called funding a trust. And as a result, if you don't fund your trust properly in California, if you die, it has no purpose. We still have to run to court, do a court proceeding, grab all of your assets, put them all back in the trust. So that by far is the biggest mistake when doing a living trust. Now, I would say the other mistake across the board is, again, the self-prepared documents. You don't know what you don't know. So when you're filling those things in, you're putting things in the wrong spot, you're not following direction. And if you pass away or if you end up in the hospital, that can have a really horrible effect.
So talk to us a little bit about, first of all, I do want to comment on this funding of the living trust. When I established a living trust myself, I didn't fund it for several years or a number of years until I was told that, because now it's totally negated, means nothing. But would you explain to I was going to make an assumption here, perhaps I'm wrong, that most of our participants are California residents. So the living trust, tell us the exact advantages and the money that we save, how important this living trust is to California residents.
Yeah, I'm happy to do that because I also practice in probate law. And probate law is what happens when you have to go to court. And what surprises people the most is that if you pass away with just a last will and testament in California, that must be overseen by the probate court judge when you die. One good example I use a lot is the Michael Jackson estate. People might be surprised to know that he only left a last will and testament, and it is, of course, 10 years later, still in court. The will must be overseen by the court. That's it. Bottom line. The will does not avoid the probate court if you die. The trust, however, does, because again, it's like a little business. It's an entity. It does not die just because you die. It can carry on for your family. And the only way it works is if you do, in fact, fund your trust. And what that essentially means is changing the title on all your assets to match the title of the trust. So if it's the Angela Dailey Trust, your house deed must say the Angela Dailey Trust. Your bank account must say the Angela Dailey bank account. It has to match exactly for it to work. Again, otherwise it's just an empty document with no meaning.
Well, I better go into Wells Fargo and change my personal accounts there pronto.
That's right. That's right.
So in other words, we save a lot of money and time. I mean, if Michael Jackson, we're realizing that his is an enormous estate, but if you don't have this living trust and you're in probate court, it could be years before your heirs get this whole thing settled, correct?
It's so true. And that's if, if there's a family fight, then all bets are off. Anything can end up in court. But just for a regular trust, if you want it to pass to your family with no strings attached, if you don't fund your trust, then I have to run into court with your trustee, ask the judge to confirm that you meant to put all of your things into the trust. And that, by the way, costs about $5,000 for that process. So you've already doubled the cost of your trust if you didn't do it right. And the courts are so jam-packed right now across California because of COVID, because of the short staffing. We can't even get hearing dates now for very simple things for 9 months. Wow. So there's your beneficiaries are going, hey, where's my money? And we can't even get the trust up and running yet until we get all of the assets put into it.
That's really could become a very serious problem. I mean, just think about if you can't get the assets, you still have to pay taxes on the property. If you have a condo or whatever, you're still going to have to pay condo fees. And meanwhile, you can't touch the estate.
That's exactly right. And it's to your point, let's say that you don't have a bank account that's available to pay bills because it's, somewhere off in the Netherlands. Your trustee has to pay out of pocket for your expenses, or your kid does, or whomever is left holding the bag. Now they're out of pocket. They have a trust that has no effect. They're in court and they're mad at you as your loved one.
They're mad at you that you died this way, right?
Right. And left things undone.
They're mad at you. Oh dear. Oh my God. Well, okay. So let's move here to some interesting situations. And I'm going to paraphrase Tolstoy. Each family is different. We have a lot of blended families unfortunately, because of divorce. That's so right. Now you have husband and wife, they each have children, and they're bringing the children together. Maybe they have children together. So how do you deal with these blended families? Now the wills have to become a lot more complicated.
Absolutely. And it's, it is the nature of our modern society that we have these blended families with kids from different marriages, more younger people who have wealth when they get married and are joining together their assets, as well as, just the complexities of modern life. Divorce, 50%. I think it's actually more in California, more than 50% of couples get divorced. Mm-hmm. So you have to, and this goes back to your question about picking the right plan, the right trust or will for you. It's so important to think about, if you pass away first and I say that, okay, I'm leaving all of my assets to my husband, but I want to make sure that he then leaves my part to my kids or to whomever, you have to have a specialized trust or will to do that. Because then you're just saying, good luck, honey. I hope you do the right thing. Please don't get remarried and give all my assets away to the new spouse. It is critical to have that conversation with your trusted advisors and pick the right documentation for that.
Yeah, that does sound really, really important because, we all have our own wishes for our children and in blended families together. So, we get to other touchy subjects. For example, what happens if you don't want to leave your estate equally to your heirs? Mm-hmm. So we have 3 children and one is perhaps a black sheep, or perhaps not as well off as the other 2, not as successful, or has special needs. How do you work around this so that there isn't bad feelings in the family after?
Right. Oh, it's such a great question. I think I could give a whole day's presentation on that topic, but it's important because when I first took my wills and trust class, and my professor, who was so fabulous, she started the class by saying, listen, everybody, inheritance is a gift. You don't deserve it. You didn't earn it. You're not working for it. It's a gift that someone generously gave to you out of the kindness of their own hearts. And if you start from that premise and then you work into what the client wants, you'll find different things, right? For instance, if there's clients or a client with a child, for instance, with special needs, let's say, that's a whole different ball of wax. You absolutely have to make sure you plan for a child with special needs who might be receiving government benefits, who might need extra care over their lifetime. And there are ways to do that where you can structure a special trust, and in fact, it's called a special needs trust for that disabled child. But again, the most important thing that this all comes back to is, who are you going to put in charge of this? You have to think so carefully through who you're picking as your executor or your trustee. Some of my clients, especially sort of what I'll call old school, they go age. Oldest is Bobby, second is Johnny, and youngest is Sam, and they put them in that order. But they didn't think about who has the best skill set to be the executor or the trustee. All of your best laid plans have no meaning if you're not picking the right person in charge. And that really is the essence, I think, of all estate plans, is who is your person that you trust implicitly to be in charge. And then everything comes from that. So then, to your point, Angela, if you have special situations with kids who don't get along, shockingly, not all families are in fact the Brady Bunch. We do have different personalities and conflicts, and that's the nature of every family. And so putting in charge, for instance, the child who is, steamrolls everyone else, doesn't really listen, maybe has some financial messiness of their own, divorces, bankruptcies, can't balance their checkbook, not a good candidate for a trustee or an executor. Mm-hmm. And certainly not the person who's going to treat everyone in the family loyally and neutrally. So you might have to think outside that, group of people. Maybe it's not one of your kids. And there's lots of options for that, right? There's other family, friends, and potentially professional trustees or a professional executor.
Mm-hmm. I heard once a financial advisor, which struck a chord with me, said, it's not a good idea to name your children as the trustees, because it could end up fighting about things, and to leave it to a relative when you can, a trusted mm-hmm. relative. But it is a really sticky situation, because you never know, as you said, you get kids married and then their spouses get involved in all of this. So you really have to be careful. So if people wanted to go into a direction of a professional trustee, what are the implications of that?
Yeah, we have in Orange County, we have some great professional trustees to choose from. And there's sort of two levels, if you will. There are the corporate trustees, who are the actual trust companies. There are banks who have trust departments, and those folks have been around a long time. They can handle big estates. Mostly they're not really cost efficient for smaller estates per se. And a smaller estate around here is under $1 million. And then there's individually licensed and bonded professional fiduciaries. Now, I'm hoping that not everyone saw that most recent Netflix show, I Care a Lot, with the professional conservator. That we got a lot of phone calls asking if that was right or not. And luckily it's not right. It gives a bad name to some really great professional fiduciaries, but they are there. They are licensed. They're bonded. So they carry errors and omissions insurance in case there are any mistakes. And they step in if there's a fight going on in court and we need to remove a trustee who's not doing a good job, or two, you name them at the outset because you already anticipated that maybe your kids are not going to all get along when it comes to, dealing with your estate if you die. They do charge for their time. They charge hourly rates, usually around $150 an hour, give or take. But here's the secret. All trustees in California, whether they're a professional trustee or a child, they can charge for their time. And I tell clients this: your kid, Johnny, he can charge a trustee fee too. And there are, of course, families who say, no, he's not going to charge a fee. But when you're done settling someone's estate and you realize how much work you've just put in, I guarantee that someone's going to think twice about paying themselves for their time.
And if they were paying themselves, what would that be? Is that an hourly rate or a guest or a flat fee?
Yes. Again, God bless California. We make it so difficult. It's any of those things that seems reasonable.
So there's no percent of the estate, or so that they can't go hog wild though, because then people would contest, right?
Exactly right. So what you do is at the end, and again, if I was settling my parents' estate and I have everything ready to distribute to my brother and sister, and I say, okay, brother and sister, here's everything I did on behalf of mom and dad. Here's the bills I paid for. Here's all the assets I sold. Here's what you're each getting. Here's what I'm paying myself. They have to review it. They have to sign off on it. Otherwise, we all end up in court fighting, and it's a big hot mess.
Yeah.
That happens a lot.
So they're going to court. How often are wills contested? I mean, for example, that situation where you don't leave. I mean, you have a special needs child, hopefully the family understands, but, you just have someone that's out of favor or a black sheep, or the mother, the parents believe that because they need the money more, they should get a little bit more. How often are those situations contested, and how do you avoid that?
Right. I mean, I think it's a interesting question. I'd love to know what the statistic is. I don't think, luckily, us lawyers, we only hear about the bad cases going to court. We don't hear about the ones that work out beautifully. They don't need us.
Yeah.
So unfortunately, we just hear about the bad ones. And we've seen things that, the client put together a beautiful plan. They thought everything was lined up, but you get the one black sheep to trump up some kind of thing about mom or dad not doing the right thing, and you can go to court. And that's really unfortunate. So when that happens, I talk to my clients about putting some safety nets in place, some safeguards. For instance, one thing that's really helpful is when the client writes a letter, a handwritten letter, into the file. It comes out when they pass away. We read it out loud so that everybody knows mom and dad's wishes and why they may have done something that was either unequal per se, or helping one child out more than the other. It's a very powerful tool. But honestly, what I prefer is to have the family discussion beforehand. It doesn't have to be over the Thanksgiving dinner table, but a meeting amongst the kids and mom and dad. Here's what we're doing and why. It's not because I don't love you more or less, but this is the way we want to do things. And that can head off a lot of potential disputes.
Yeah, I could see that it explain the situation rather than just seem arbitrarily to do this. Tamsen, so we're hearing with the new administration that the new taxes that might be imposed on estates. What are you hearing about this, and what do you think is likely to happen over the next 4 years? And is there any way that we can prepare for this, or think about it, or incorporate it into our thinking about our estate plan?
Yeah, it's the Mark Twain quote is true. The only certainty in life is death and taxes. And my colleagues and I, joke about it, which I'm sure it's not a joke to most people, but these constant tax changes, keep us all in business, because it's soon as we get something situated with our clients' plans and we know what we're dealing with, and then the tax laws change. And that's, of course, on the federal level as well as the state level. And I'll just make a side note that is probably the most important reason to check in with your lawyer to see if the tax laws have changed. That would affect the way that you put your plan together, as well as other things too, by the way, retirement account planning, all of those products where we're stuffing income tax-free money, 401ks, IRAs. There's some new tax law changes on those too. So it's really critical to stay in touch with your professionals, your CPA, your financial advisor, your lawyer, to see if those changes affect you. So there's been some doozies over the past couple of years. So we had one really good change, which was that the inheritance tax. Okay. It's known as the death tax, but it's really called an estate tax. Mm-hmm. People are fearful of it. They think that there's going to be a wipeout of their estate when they die. Luckily, it now only affects people who have $11 million or more, and that's per spouse. So if you are one of those lucky few who has a $22 million estate, there's an estate tax on anything above the 22 million. All of us regular folk in the middle class and whatever, we don't have to worry about the death tax. That is that's a bonus. Over time, it's been a lower amount. It's been $1 million. So if anything was over $1 million, it was taxed. Thank goodness that's all gone. 11 million and over. Okay. Now you can still give money to your kids for free. And that's a $15,000 a year gift for all of your kids. You and your spouse each can give 15,000, no tax by anybody. No one reports it. It's free money. So again, good for you. If you got that extra money and you want to give it away now, 15 grand per year, per spouse, as many kids, as many family, however you want, give it all away. Great. So those are the two big ones. Now, the one thing that's changed here recently, again, is the tax on retirement accounts. And this gets a little bit nitty gritty, but we're also attuned to putting away tax-free money so that when we retire, we can take it out and we pay the tax. Well, if you don't use up your retirement account and you leave it to your kids, they too pay the income tax. And if they're still young and they're working, they're paying at their income tax rate, a higher income tax rate. One loophole that was recently closed is that in the past, if you left a retirement account to your children, they could roll it over. It's called an inherited IRA, stretch it out over their lifetimes for distributions, and even pass it on to the next generation. And that loophole's been closed. Now, if you leave a retirement account to your kid, they have to drain that retirement account over 10 years and pay all the tax in that time. And that's the end of it. It really shoves down that income tax to your children or whomever is your next beneficiary and speeds up the payment of it. Congress wants their money, and that's the way that they found it. So critical that everybody here who has a retirement account, either through their company or an individual retirement account, if you're building up a lot of money there and you're not sure you're going to be able to spend it all in retirement, you better start thinking about different ways to deal with it, because
to get some of it out of there, perhaps.
Absolutely.
Or have the children at least thinking about strategies, talk to their accountants, because there are ways to, whether you take it out year by year, or you take it out all at the end, or you take it out all at the beginning, all kinds of things that could implicate that. Well, I think that even in the last decade or so, we've seen so many tax law changes that makes your head dizzy.
It's frustrating for people. It's frustrating for professionals. I know we have CPAs and financial advisors in this group, and you're just constantly playing catch up and trying to learn what it is.
Yeah. So it's something. What tells me is that I guess we can't get too upset about what the tax laws are now, because who knows what they'll be when we all pass on.
I totally agree, Angela, and that again is why I tell clients, call me up in 5 or 7 years and we'll check to see if your documents still work.
I want to invite the audience to put in some more questions because I have a few more questions for Tamsen, but then we're going to take questions. So please fill in some questions in the Q&A box. So Tamsen, let's talk a little bit about the softer side of, you alluded to this about the why you put together a letter on why, you decided to divide your estate not equally. But what about other things that are more positive? For example, just in the Wall Street Journal today, they had an article about ethical wills, where people will take the time to explain what their important values are and to try to pass on a legacy here. Have you seen that and seen it done well? And do you have any recommendations that if our participants would like to do something like this, how they should do it?
Yeah, it's a really interesting topic because, as we all know, well, maybe but I don't think you can speak from the grave, maybe. But the best thing you can do.
I don't think we can, no.
Some people might differ. Okay. Again, that to me, not having a document that's sprung on someone after you die, that's not great, right? The most important thing is to have the conversation with your loved ones beforehand so that they hear what you think is important. I have clients who are, either strongly charitably inclined, who have really specific wishes about how the trust funds are going to be handled investment wise. We all have, of course, pets. I'm a big pet lover.
Yes.
How are you going to take care of your pets? And so whether you do that in a written document or sort of an audio format or a video format, There's no right answer, but I will say that if you do video or audio, and this is coming from the lawyer's perspective, that video and audio then comes into court as an exhibit. So the most important thing, and this is one of your questions earlier about avoiding mistakes, please don't wait until it's too late. Please don't wait until you make your ethical will or your video or your audio recording when you're super ill, you're on your deathbed, and you'd be surprised, I'm called to hospital bed signings. Well, we need to hurry and rush and get this will done. It's not the time to do it. Mm-hmm. Do it while you're well. Do it when you can, again, have a conversation with your loved ones, tell them what's important to you, and then it starts to flow from there. This is especially important, by the way, for our audience who might have young children. I have a sort of a tip sheet that I give to my clients about how to take care of your kids. God forbid, this is worst case scenario. What if you pass away and you have young children? Who are their doctors? What are their medicines? What food do they like and not like? Who's the best person to take care of them physically? My sister, Amy, might be great with kids, but she can't balance her checkbook. So my sister, Sarah, balances the checkbook. Those are things to start thinking about in advance. Getting those down into a written letter or written directions is just critical.
Yeah, and we don't think about that, especially young people. It's very hard. I find with my own sons that if I mention will, they all get upset. Oh, mom's such a morbid topic. I think it's necessary to discuss.
Absolutely.
And with that, one more question for you, and then I see we do have a few questions now in the Q&A box. So I have spent a lot of time on codicils to my will, leaving bequests, small bequests to people and little instructions about jewelry and artwork and all of this. What is exactly a codicil?
Okay, yeah, great question. And I want to talk about the personal property items too, because you made me think about that. But if you have a last will and testament, every time you change it, it's a codicil. Okay, and it's just terminology we're talking about here, but it's a change to your will. If you have a trust, you make amendments to your trust. Same general concept. They're changes. You can make as many as you like. That's fine. I will caution, though, I have had people who make amendments to their trust or their codicils to their will once a year. It starts to look like you don't have a rhythm in your mind of what it's going to look like. Worst case is you're constantly changing it with kids. I love Johnny more today, but tomorrow I love Jimmy more. That's not good. So you really should think about, before you hasten to make a change because you're mad at one of your kids one day, calm it down, think more about the big picture. The last comment I'll make is about the jewelry, the personal property, the mementos, the most family fighting over those things. I can't even tell you. So, you as the parent might say, I don't care. They can go through the house and pick whatever they want. But I guarantee there's going to be a fight over, grandma's teapot or whatever it is. Write those things down, give them to people want them, and then even better, create a mechanism by which they have to use to pick the things. It will greatly reduce the family fighting.
Yeah, I read about that somewhere, that they pick a number and then they alternate back and forth.
I had clients doing a rock, paper, scissors game. I don't care what it is, as long as it's in writing, it's what you want, and then they can follow it.
I think we've all had those experiences with children that we don't realize what's important to them. To us, it's an old book, but to them, it's something, a cherished memory. So anyway, all good advice, Tamsen. You did a fabulous job. So we do have a bunch of questions, and I'm going to turn this over to my partner in crime here, Darlene March, our COO, and she's going to field the questions.
Okay, can you hear me?
Hi, Darlene.
Hi. Okay, I see Sonia. Do I see Darlene?
You don't have, we can see you, Darlene. So just go for the question.
You can see me? Okay, great. Yes. Okay, here's the first question. It comes from Camilla, and she says, does designating beneficiaries for certain accounts or using a TAOD, which is a transfer on death, designation on brokerage accounts, make them exempt from probate?
I'm So glad that question was asked, Arlene. I just jumped in too soon. Was that the end of the question?
Oh, you need to hear it again?
No, I'm sorry. I got so excited about it that I jumped over you. But if that's the question, I'm glad that that was brought up, because you can basically plan an entire estate without a will or trust if you only have assets that you can name beneficiaries on. And for instance, if you don't have a house or you don't have a business, and let's just say you've got almost all exclusively securities, stocks, bonds, cash, life insurance, you can go through and list beneficiaries on all of those, and those will be exempt from probate. They pass without probate. They go directly to the person named. That person turns in the claim form to the company that holds the account, and it's theirs. Done. Very, very easy when you have assets that all are able to name a POD, a pay on death, a TOD, a transfer on death, or a beneficiary. So really good question.
Okay, here's another really good question. Given that some situations are much less complicated than Michael Jackson's estate, what would be an example of a situation in which it would not make sense to set up a trust given the simplicity of the circumstances?
So that is also a great question. Now, I mentioned at the beginning that California makes it difficult to live and die in, but it's beautiful here. Okay. If you have assets that are worth more than, and this is a weird number, $166,000, and you can't name a beneficiary on them. Okay, so let's just say all you have is a house. You don't do a will or trust, it's going to probate. Even if you only have equity of $1 in your home, that part doesn't matter. If you have a gross estate worth more than $166,000 and you die without a will or trust, it's going to probate. So other states have simpler procedures that have either higher thresholds or easier mechanisms, but not here in California. So I tell my clients, hey, let's say that you go, well, I'm not wealthy enough to have an estate plan. All I have is, my house and my bank account. But your home here in Southern California could be worth $1 million. Maybe you've got a giant mortgage on it, but that doesn't matter. If you die, it goes to probate without the trust. So it's 166,000 is the threshold.
Okay, we have another one. Akila, are there methods to protect assets if you own a revocable trust and place the trust in an LLC? Is it worth the additional cost?
That is, I'll state for the record that that's a different answer for everybody. The LLCs in California and in most states are a great vehicle to own business assets. And one of the common misperceptions, and some marketing guy in Nevada came up with this, you can put your house in an LLC and protect it from creditors. No, you can't, not in California. If it's your personal asset, an LLC doesn't protect it from liability, and neither does a revocable living trust. The revocable living trust in California only protects it if you die or if you become incapacitated. Now, if you have business assets, true business assets, rental property, your law firm, your shop, and you put it into an LLC, great. What you're doing is really just cutting down on the possibility that you get sued for everything you own. Okay, so it just separates the liability, personal, business. But don't put your house into an LLC. It'll cause a whole bunch of problems.
Okay. How are adopted children treated in wills? Is it different from birth children? And is there still a reason to leave $1 to someone?
These are such great questions. I'm so excited. Okay. In California, legally adopted children are treated as if they are biological children. No difference. The key is that your adopted child is, in fact, adopted from a third party, not from a step parent. If you do a step parent adoption, the other biological parent must give up actual parental rights for them to inherit from you. It's a little bit of a tricky item there, different in different states. But generally speaking, adopted from a third party, the same. Okay. The dollar, the dollar for no contest. So let me say again that I love practicing in California. It's a great state. We make it so easy for people to sue. We want people to sue each other. We want to have our, everybody have their legal rights heard. If you cut out a kid and you say, I'm leaving you $1 not to contest, well, what do they have to lose? $1? That doesn't sound great to me, right? But if you say, I'm leaving you, little Johnny, $10,000 not to contest, well, now little Johnny has to really think hard about whether he wants the 10 grand or he wants to try to contest, spend a whole bunch more money in legal fees, potentially lose the 10 grand. That dollar concept, it hasn't worked for a long, long time because our law in California opens up the contests to anyone who has a reason to believe that they can contest. That's the essence of our law here. If you're mad at your kid and you want to disinherit them, you can. It's your money. You can do whatever you want. But you have to take some of these really cautious steps, letters of intent, having a lawyer prepare the documents, because otherwise California will give that child the opportunity to contest whether you liked it or not.
Wow. Hope that doesn't happen to me. What are some of the checks and balances for a non-family member conservator in California? For someone without children, how do you ensure someone you hire will help you make the best decisions for you when you become incapacitated or unable to make decisions for yourself?
So this goes to someone watched that movie, I Care a Lot, on Netflix with Rosamund Pike. So back in the old days in California, believe it or not, professional conservators and private professional fiduciaries had no regulatory oversight. And it did lead to some pretty bad cases of undue influence, fraud, et cetera. So that stopped back in 2009, I believe, or 2007. Now, the Secretary of State of California oversees all professional fiduciaries. You have to be licensed. Almost all professional fiduciaries carry insurance for mistakes. But I think the most important is like anything else. Go and interview them. Get a good referral or a handful, interview them. Ask for referrals. Ask for their fee schedule. Ask them what they would do if you're disinheriting a child and how they're going to handle that. You have to interview these people to see if you like them, how they're going to handle a difficult situation. Are they going to be around for your family to resolve these potential disputes? To me, that's the most important. And it does sort of go to something that we talked about at the beginning, which is this large baby boomer population who is going to be sort of retiring and aging out. And they don't all have kids, one, to take care of them or who will take care of them. And so there's a big growth in private professional fiduciaries to sort of handle this aging population. They have purpose. Now, I think the other funny thing about the conservatorship mention is that we all have Britney Spears on our mind, right? What people need to understand is that if you are the subject of a conservatorship, you are gravely disabled, subject to ongoing undue influence. You've got someone who's constantly taking advantage of you and you can't decipher what's right or wrong, or a mental illness. It is the worst case scenario. And it means if you're under a conservatorship, it means you're really, really sick or there's no other alternative for you. So you don't want it. You certainly don't want it. And it goes back to that healthcare directive I talked about at the beginning. You have to pick someone who you can trust, who will do the right thing, who will be loyal, neutral, and take care of you in the manner that you want, right? Not them. If you say, I have long-term care insurance, I want to be kept at home. Okay, now that person who's taking care of you knows what your wishes are, knows where the money is to do it, and will hopefully follow your wishes to the greatest extent possible. It's a very personal relationship.
Wow, great. Okay, we got some more. Are there any special considerations to take into account when heirs may reside outside of the United States and are not U.S. citizens?
Yes. It's funny because we do pretty in-depth continuing education on this topic, and not surprisingly, everyone, the reason for this is because of taxes. The United States government wants to tax your estate, wherever it may be. If you are someone who came to this country and left a country and had assets there, or you acquired foreign assets while you live here, the US is going to track it, first of all. Okay. If you leave money to someone outside of the United States, you still have that $11 million exemption that I mentioned. But that country, and a lot of those countries, by the way, are the Commonwealth countries, Germany, Italy, the UK, Spain. They have tax on money coming into their country. So you have to speak with your person that you want to leave money to, ask them if you don't know what's the rules for money coming into the country. Is it going to be taxed? Because then you're trying to do something nice for that person, but it's, for instance, Germany has and Canada too, has what's basically a capital gains tax on money coming in to their residents. So that's part one. The other part is that you also have to be extremely cautious about naming a non-US resident as your trustee or executor. Again, there's some tax rules that make it difficult. So if you're going to do that, I would just really highly suggest discussing it with a qualified attorney.
Wow.
These are really good questions, really, really technical.
Yes. Okay. Jackie wants to know, just to clarify, you can give $15,000 per year with no taxes?
I know, it's shocking. We always think there's got to be a tax on everything, but the purpose of that is to allow you to give money to your kids and not have anybody worry about a tax. So shockingly, the government thought about that. It used to be $10,000 for a really long time. And along with that, a state tax threshold of 11 million, it's just been going up and up every year. So you've got 15 grand per kid, per person, per whoever, limitless every year. If you want to give 100 people $15,000 this year, you may, and there's no tax, not by you, not by them.
Okay, it's $15,000 per child for the husband and the wife. And so that would be, so if a husband and a wife would each give $15,000 to two children, that could be $60,000 total?
That's right. So it's $30,000 per child from husband and wife. And then I have a lot of clients too, when they're purposefully gifting to try to get money out of their estates. You can do, your kid and your kid's spouse and your kids, the grandchildren, as many as there are. So each family unit, they can each get the 15 per spouse, so 30 total. So if you're really trying to get money out of your estate, it's a pretty easy way to do it. You just write the checks and you're done.
Great. Okay. What if you want to leave money, but your child is not responsible? Can there be conditions given in installments?
Yes, there can, and there absolutely should be conditions. I can't tell you how many clients, and amongst us sort of professionals in this industry, we call it the failure to launch. If you have a child who just hasn't quite launched professionally or monetarily, and you're worried that they're going to squander the money that you're leaving to them, the trust is the perfect vehicle for that, right? Because then you define all the terms by which your child or whomever can get the money from you. You pick a responsible trustee who is going to be the person who doles it out. And you then really have to decide, and this is important, how much do you want to let go? And how much do you want to control? The control that it's kind of funny, it's called dead hand control. This is a real legal term because you're controlling it from the grave. How badly do you want to control it from the grave? And how much do you just want to say, okay, I'm just going to have to let it go? It's different for everybody. But the trust is the vehicle, and it is a way that you can control it down to the last penny if you really wanted to.
Did you say it was dead in? What was the term?
It's called dead hand control.
Oh, dead hand.
controlling it from the grave with your hand.
Okay. I'm spooky. Okay. Do professional fiduciaries only start to collect their fees when you pass away, or does the meter start running as soon as you hire them?
Great question. And they only start charging you when they step in to do something, whether if it's you pass away and now they're going to be winding up your estate, or if you were to become incapacitated. Dementia is on the rise, Alzheimer's, and we have a lot of times where a person can no longer manage their affairs, and then you have to have your person step in. So at that point, the professional starts, taking action on your behalf. We call it marshaling the assets. They're getting all your assets together, figuring out what you got in terms of income, what your bills are, what your taxes are, and they'll start handling that for you from then on. And then they pay themselves based on their rates from your assets. If there are, and maybe this will sort of help with some of the folks out there who are asking, you can set it up so that if you hire a professional fiduciary to act on your behalf, in your trust or will or your power of attorney, you can say that they must report what they're doing to your kids or a trusted person so that there's a check and balance. And those professional fiduciaries are very used to doing that. They have beautiful reports and accounts that they send out when asked, as they are required to do under California law. And that can really help people feel better that there's no one to account to, because there is, and you can set it up. Who should they account to?
Wow. We have so many questions here. Angela, should I just keep going?
No, I think we'll just skip to our timetable. And if Tamsen is willing to stay a few extra minutes after 6:15 and answer a couple more questions, but we want to get to part 2 of our session here. And part 2 is on Tamsen's career journey. This is always a very, very popular part of our Tearing Down the Pink Wall series. So Tamsen, let's go back. I mean, did you always want to be a lawyer? Tell us about your career journey, because I did read in your bio that you did not have a straight line into the law after you graduated from UC Santa Barbara.
That's right. Thank you for asking. And I think this is when I talk to young people who are either heading off to college or maybe thinking about a different career, my best advice is don't be afraid to switch gears, because you don't want to go down a path and find out that you don't love what you're doing and then have to, either not be able to switch for whatever reason, whether it's, family obligations or financial. I was on the path to doing public relations for high technology software startups. And at that time in the 2000s, that was a big industry, lots of opportunity. I got to travel. I worked with CEOs, vice presidents of some pretty in-depth tech stuff. And I did not really enjoy it.
Why technology, not? What didn't you like about it, Tamsen?
Yeah, the technology was just not my gig. And I know that some people love it. I liked the personal relationships. I liked the problem solving. What's the product? How do we get it out there? How do we put that plan in place? And after I actually did career counseling. I talked to people. I thought through what my skills were. And it sort of came to me. I thought, I used to want to be a lawyer. I used to be very interested in that path to helping people, learning the law. And I sort of woke up one day and I said, aha, that really is it. So not to be too corny, but it was a light bulb moment. I literally woke up. I said, that's what I'm going to do. And so I did. I quit my really great job and I left the Bay Area to go to law school.
And the rest is history here, right? But that's interesting. Most of the people that we talk to don't have a straight line occasionally. But so how long did you work at your prior job, the public relations job?
I left that job when I was 29 years old and entered law school. And, it's a 3-year course in law school. So I graduated from law school. I was 32 years old. And I even during law school thought I was going to become a civil rights attorney. And I was going to be there helping people with their civil rights. And I realized that was not my path because that type of law was not for me. And that estate planning was it. It just felt right. I loved sitting down with families and working out, these issues that we've been talking about over the past hour. And I look back, I go, I just would have not have planned that, but it's everything I hoped it would be, and I love it.
Well, that you have to love you. If you don't love your work, you're not going to be good at it. And you are obviously very good at it, Tamsen.
Oh,
Tell us about how important were there mentors in your life, and who were some, maybe one or two that really made an impact on you?
Yeah, I talk all the time about my professor in law school who, I was a good student. I wasn't the brainiac, I suppose. I didn't go to Harvard. I went to a good school here, but that class really clicked for me. And I spoke with that professor a lot about how I could put together a career in this area. And from there, I sort of pounded the pavement. I talked to a lot of attorneys out there who were very gracious with their time. And that's really what you have to do, knock on a lot of doors. Now, I will say that I worked for a small firm for about 2 years. And then one of my friends called up from law school and said, "Hey, we're opening our own law firm to do wills and trusts. And are you interested?" And I said, "Absolutely, I will be right there." Because I'm sure, like many business owners who are here, I like to do things my way, the way that I think they should be done. I like to treat my clients the way that I want to be treated. And that is the best part about having my own firm.
Yeah, that was going to be my next question. Why did you decide to be an entrepreneur here? Because, you were working at a law firm. I guess you could have gone the opposite direction and gone from a small law firm to a big law firm, but instead you decided to do your own thing here, essentially.
Absolutely. And it was a not that scary step, which is pretty cool in retrospect, because opening a business is very scary. But I felt so good about how I wanted to practice law, how I wanted to provide customer service the way that I would want to be treated. And that's really what we focused on over the past 15 years with this law firm, is treating people with the decency and respect that you yourself would want to be treated with. And with my public relations background, it helps because you sort of see how, the customer wants to be treated too. And that's why I went in that direction and not to big law.
And tell us about, now you're an entrepreneur, you have your own firm, your own company, essentially. What are the challenges that you face?
Yeah, so myself and my business partner, we both come from backgrounds with, again, a customer service orientation. And so we built this law firm more like a business, I guess you would, versus a law firm. Lawyers are notoriously not that sociably skilled, but the same pressures of a business owner are the same with law firms. And it's, if I go on vacation for 2 weeks, who's holding down the fort? Who's taking the phone calls to bring in the clients? It's the ups and the downs. When you're really, really busy and you go, "Oh my God, I need a vacation," and then you're slow, it's like, "Oh my God, I need more clients." And that pressure is constant and always, I suppose, will be. So it's the same as all business owners, as same thing with a law firm.
And so it sounds like, though, that you wouldn't hesitate to do this again. This is the path that you have chosen. We started out this conversation, you were giving some advice to people, just to the younger crowd here. So, but it also seems like that advice is applicable to people that are into their 30s and perhaps beyond, that if they're not really keen on what they're doing, would you advise them to take steps like you did? Too risky, not risky, and not what advice would you give people that are either planning a career or in the midst of a career and want to make a switch?
Yeah, I think it's such an interesting question. And of course, it's different for everybody, because one thing that was different for me is that I was not married and I didn't have kids when I went on this journey. And that it was just me, I packed up my bag and off I went. Now, there were other people in law school with me who were married with kids. I think the oldest woman in law school, if I was 30, she was 60. And that takes a lot of bravery. But her message was that she had been working in a law firm all those years. And she said, "You know what? I'm as good as anybody else here, and I want this law degree. And so she got it. I do think it takes a lot of self-reflection. You've got to have that kind of support system in place so that it does work. That's, I think, probably the most challenging part. The financial part is difficult too, and you got to work out that path as well. But I can't tell you, Angela, I firmly believe 100%, this is your chance. If you don't take the chance now, you're just not going to ever have it. So I say go for it.
So that's inspiring. I mean, as someone who's well into middle age here at 60 can make a switch like that. So just don't let barriers stop you. I remember a boss of mine saying, knocking into open doors.
Yep.
If you want to make a switch, go for it. I mean, you did it at an early age, but possible at any age.
I think so. And it's if you really want it, it's about perseverance. I believe that 100%.
Yeah. Yeah. So you've been a lawyer now 15 years. It doesn't sound like you want to make any more career switches.
I think I'm done. That's right.
Done with career. All right. Well, listen, this was really fascinating discussion here. Really interested to hear your comments, and very, very inspiring, by the way, in terms of career. And don't let things stop you because you on one course. Don't be afraid to change. So, Darlene, if you want to get a few more questions in, let's keep going for about another 10 minutes or so, and then let people go.
Okay, let me unmute myself. Hold on a second. Yeah.
There you are.
I think a lot of people got excited about giving away $15,000 because and I have about 4 questions on it. So let's kind of group them together and say, if you say, let's just say you take $15,000 from your IRA account. So, and you want to give it to a beneficiary of any kind. It could be anyone, right? It doesn't have to be just your kid. It could be a charitable organization. So how does that work? You pay taxes on your withdrawal,
sure,
of the IRA if
right.
It's not required minimum distribution.
You got it.
And but any money that you give away, you don't have to pay taxes on directly. Is that
right?
Correct?
So, and I heard you say one thing I want to qualify is that gifts to charity are limitless. You can give, like the Bill Gates Foundation, $50 billion to charity, no tax. So you can give your entire IRA to a charity, no tax. And that's a strategy for some people. If you withdraw money from a traditional retirement account, and for those financial planners out there and CPAs, they know this. You put the money in tax-free. When you take it out, you pay the tax. I don't generally tell clients it's a great idea to take money out of your IRA, pay the income tax, and then give away the gross amount. That kind of stings because you're paying the income tax out of your own pocket, but then you're giving away that money that you just got taxed on. It's not great. You can do it if that's your largest source of wealth, but there are lots of things that financial advisors can do these days, like rolling over IRAs to what's called a Roth IRA. So that way you're converting, dollars that haven't been taxed yet to taxable dollars. Then you reinvest it, then it grows, then you take the money out and you don't pay the tax on the Roth IRA. But it's not the best source of giving the gifts because of that income tax ramification.
Okay, so this would be money that maybe is in your bank account that you want to give away.
Right. Or one thing that people are doing a lot, because there's a lot of talk right now about capital gains rates going up. So let's say you have one share of Google stock and you just hold the stock certificate. You just give that to your kid. Okay, fine. Let's say it came at a basis of $10 and now it's worth $1,000. You give it to them at the $10 basis. They then pay the capital gains tax if they want to sell it. That's a pretty common strategy of just shifting away taxes from your estate and shifting it to the other generation. There's a lot of gift strategies. I always tell clients, hey, it's really easy to give away money. It's not as easy to earn it. So once you want to start giving it away, get with your CPA and your financial advisor and start working on some strategies.
Great. Okay. Maybe one last question. we have what I thought is a very good question here. Who determines if you are incapacitated?
Hmm.
Should the incapacitated be defined by a medical professional or just be stated in the healthcare directive? Who decides?
Such a good question. So, and this again makes me think of the Casey Kasem case. If anyone else remembered, I listened to him because he was the top 40 DJ when I was growing up, and he counted off the top 40 songs. Well, he had a horrible battle with wife number 3 and his kids. His daughter in particular was in the news a lot. The wife had him moved out of state, declared incapacitated by 2 doctors, which is probably the most common mechanism, and then tried to take over. Well, the daughter had to fly out of state, schlep him back here, and then it all went in front of a judge to determine if he had capacity or not. That's your worst case scenario. Your best case, you put it in your documentation. You either do doctor's evaluations, either your primary treating physician evaluates you and determines if you have full mental capacity to know what you're doing. 2 doctors is probably the most common, primary treating physician and a backup, a specialist. Some families will even do a committee of their loved ones. If you're lucky enough, for instance, to have medical people in your family, maybe you just set it up that your 3 kids talk and vote. And we do that sometimes too, because there are clients who would rather have it be a private thing that just the family works out. But it absolutely should be stipulated in your documents. Your medical directive should state it, and your trust should state it, because you've got your medical person and you've got your money person. And those people both need to take over based on this mechanism that you put in your documents.
Okay, this is another, I'm going to wrap this up, but I can't, you should be able to answer this quickly. Do you specifically need to list an ex-spouse to ensure that they are not part of the estate or cannot contest it?
Good question. The answer is 2 parts. In your trust and will and your powers of attorney, your ex-spouse is automatically out once you get divorced. Gone. They are treated as if they died before you. Okay, like they don't even exist. But this is so important. I think it is a good note to end on. Check those beneficiary designations. Your 401k and your life insurance are governed by federal law and not state law. So if you get a divorce in California, they're not divorced for federal purposes. You must go and take them out of your 401k and life insurance. Otherwise, I get this call all the time. Hey, my ex-spouse left me this 401k, and the kids are kind of upset. So if you get divorced, go through each and every account and just do the homework to make sure that you remove that ex-spouse from all of the accounts and the 401ks and life insurance. Otherwise, they get it if you die.
Okay, Angela, I'm going to turn it over to you. And
All right. Well,
thank you.
Tamsen, can't thank you enough for all of
My
your time and
pleasure.
all of your insights. I hope of all of our participants found this as fascinating as all of us. So we thank you. And we are planning a second in this series on estate planning with on December 2nd with Susan Alpert, who will talk more about the logistics of this and the documents you need to collect. So we're going to continue this discussion. A special thanks to Darlene and Sonia for organizing this and doing such a great job with the organization. So thank you all for joining us. And until our next event, please stay safe, healthy, and prosperous. Thanks for joining us. Bye-bye.